good evening guys. I hope you're having a great day. I hope you had a great lecture with your maths faculty, and to all of those, good evening Hafiza, Kumud, Ankit, Jashanpreet, Devashish. Right, so from today we'll try and keep it short because I think some of you are saying that the lectures are too long probably. So we'll try and keep it short. So I'll just straight away start with the maxim of the day, which is de minimis non curat lex. आज मैंने इसका मीनिंग नहीं लिखा है so that you guys don't copy that. Okay, good evening Rajkumar. चलो, whoever knows the meaning of this, please tell me, please write. De minimis, yeah, you can guess, no problem. You can guess, I'll give you a hint. देखो, if you can understand, damage is non-curable. नहीं, you're not even close. Whenever you use this word, कुछ minimum करके सुना है? Minimum मतलब थोड़ा कम, it's less, something which is less. And what is the meaning of lex? I have underlined only those words which I think you would know, right? And this is non. Non matlab it makes the statement, it gives a negative flow to your statement. You have tried Kumud, that's great. It's not correct though. कोई और try करना चाहता है? So basically this is a principle which is not concerned with small things, right? Law does not take care of trifles. I hope you are not just googling it and writing the answers, right? Law is or does not take care of trifles. कोई बता सकता है इसका क्या मतलब है? What do you mean by trifles? What do you mean by trifles? Can anybody tell me? Trivial issues, right? Something which is not big, something which is not huge. So यहाँ से आया है, ठीक है? Minimus से. Why I am telling you all these things is, आगे if you find these words, you might be able to connect and give an appropriate answer. So law does not take care of trifles. Trifles matlab trivial things, right? Now we have this concept in every law. ठीक है? It's a very general statement. When we talk about a contract, suppose I tell you that one of your names I'll take, Jeevita. Okay, so if I tell Jeevita that please come to my place for dinner at 7:30 and I'll cook very nice things for you, and say for instance Jeevita doesn't turn up. Okay, I'm waiting for Jeevita but she doesn't turn up. So what happens? My food gets wasted. Now I'm going to the court and I'm telling them that, see, I had a contract with Jeevita. She said that she'll come to my place to have dinner at 7:30, but she didn't come and all of my food it got wasted. I need compensation for the loss. So what will the court say? Ki we are not sitting here to solve your trivial issues. So that is how it is a trivial thing for the court. For the law, it's a trivial thing. Ki please you sort out yourself. It's not a dispute per se. ठीक है? Similarly, when we talk about section 95 of the IPC, again in in this section also we have a similar concept that law does not take care of trifles. तो इसमें for instance there were two cases. Okay, we'll discuss this in IPC also. So mainly I'll just go with these this example, right? In IPC we have two kinds of cases. One is important one, that's why I'm not discussing it right now. So in basically 95 mein, if somebody for example says that, you know, this lady, she stole my heart, she's a thief. So that those kind of things which actually the law will not take care of are known as trivial things. ठीक है? So there can be no punishment or no compensation for such issues. Now let us move on. किसी को कोई doubt है तो बताती, तो फिर I'll let them know if there's a doubt. Today we are starting with the topic of general defenses under torts. कोई doubt है किसी को? Does anybody have a doubt? Shall I move on? No ma'am, no doubt. So what is a defense? Defense क्या होता है? You know, when you watch Bollywood or Tollywood movies, the judges are there, no? They say that please call the defense, call the prosecution. So I have already discussed prosecution. What is the defense? Defense is used in a general terminology also. It's not something very exclusive to the law. What is a defense? Whenever a plaintiff files an allegation against the defendant, ठीक है, we had discussed plaintiff files an allegation, alleges something, then what does the defendant do? He defends himself, ठीक है, and whatever he states is the defense. ठीक है, तो general defense is what? When he takes the defense of something to protect himself, ठीक है, protect, I would not say protect is the correct word. Basically he is defending himself, he is denying the allegations, or maybe if he is accepting that yes, the act occurred because of me, but it cannot be I cannot be blamed, it has to be blamed on something else. ठीक है, so that will be a defense. So if he successfully defends himself, what does it mean? If he successfully uses these particular things which I am going to take one by one, then he is not liable to pay compensation, he is not liable to pay damages. So the plaintiff's suit fails. ठीक है, plaintiff's suit will fail. So whenever in the question it is written that can he take the defense? So if the defense is applicable, then the answer will be yes. But if the defense is not applicable, the answer will be no. So please take care of the language of the question. ठीक है? Is it fine till now? Now let us discuss these one by one. सबसे पहला है the defense of consent. It is known as voluntary non-fit injuria. इसका कोई मतलब बता सकता है? Can somebody tell me? Voluntary non-fit injuria. Okay. Kumud, are you saying yes ma'am? I want the answer also. So what is the defense of consent? Jashanpreet is saying voluntarily taking risk. ठीक है? That is correct. The defense of consent is voluntarily taking risk. Now say for instance there is a there's a cricket match going on. This is the stadium. There's a cricket match going on. The batsman is allowed to hit the ball, na? Is allowed to hit the ball. Wherever the ball goes, it's no concern for the batsman. So if this ball hits a spectator sitting here, then can the batsman be held liable? No, right? Because when this person bought the tickets and sat in the stadium, he knew that, you know, this is a game of cricket and the ball is, every ball may reach here and there within the premises itself. So, he may be hit by the ball, right? So, any spectator going to a stadium voluntarily takes up that risk. So, he cannot later complain. So, if there is a case against the batsman or for the organizers for that matter, it will be a valid defense. When the defense is successfully pleaded, it is known as a valid defense. It will be a valid defense. What will be a valid defense? That he voluntarily took the risk of the injury, right? Voluntary non-fit injuria, this is the maxim which is also known as the defense of consent. To a willing person, no injury is done. This is the meaning. To a willing person, no injury is done. Now, say for instance, a person goes to see a match of chess being played by Vishwanathan Anand and some other person. Recently, there was a kid playing against Vishwanathan Anand, I don't remember the name. For that, if something happens, अगर वहाँ की छत टूट जाती है or anything happens which is because of the negligence of the organizers, then this defense cannot be pleaded. ठीक है? Because when a spectator goes to see a match of chess, he is not voluntarily admitting to the risk of anything that happens within that premise. ठीक है? Now, what are the essentials? The plaintiff must be fully aware of the risk. First of all is awareness of the risk. That means knowledge of the risk. ठीक है? ये चीज याद रखना. I'll ask in 1 or 2 slides a question based on this. Knowing the risk, the plaintiff agreed to suffer the harm. The second is, first of all, he is aware. Second, he agrees to suffer the harm. ठीक है? Now, what is the third point? The consent of the plaintiff must be voluntary. That is free from coercion or undue influence. ठीक है? Voluntary. Now here I would want you to tell me if you know the meaning of coercion or undue influence, because I think I have not taken contracts till now. So if you know it, very good. If you don't know, tell me or ask me. So basically coercion is correct, use of force. ठीक है? So it's basically threatening somebody that some force will be used against you if you do not do this. ठीक है? Something which is an offence under IPC. जैसे कि contracts में coercion है, for the purposes of Indian Contract Act, the coercion is an act which is punishable under IPC. ठीक है? तो ऐसा एक्ट हम करने की कोशिश करेंगे, like threatening them with grievous hurt or hurt, that I'll murder you, I'll slap you, use all those things which are punishable under the code. ठीक है? So that is coercion. And what is undue influence? what is undue influence? Undue influence is basically not the use of force, but whenever you are in a relationship of trust with someone, ठीक है, whenever you are in a fiduciary relationship, we also call it as a fiduciary relationship. What is a fiduciary relationship? It's a relationship based on trust. ठीक है, जैसे कि husband wife, doctor patient, lawyer and his client, and what else, guru and shishya, right? So when a person A has an influence over this person B, ठीक है, it means this person is actually influenced by this person, ठीक है. So taking undue advantage of the influential position of A amounts to an undue influence. Influence can be both, na? It can be a positive influence, it can be negative influence. So if it's a positive influence, it's a good thing. But influencing somebody, for example, if a guru asks his shishya that, you know, you donate all of your property in my name, so if you don't do this, then you will go to hell, something of that sort, then that amounts to an undue influence. So whenever we say voluntary in law overall, generally, whenever we say an act is done voluntarily, it means that it is free from all these elements, free from elements of coercion or undue influence and so many other factors. ठीक है? Right? And lastly, the harm caused must not be more than what has been consented to by the plaintiff. ठीक है, तो जैसे कि if in a stadium, if the spectator has voluntarily assumed the risk कि okay, the cricket ball may hit me, but instead of a cricket ball hitting him, actually, you know, that asbestos sheet or something which is there, that falls off, and because of which he suffers injury. So that is a harm for which he has not given his consented, right? Are you getting me? Whatever I am saying, is it fine? I am taking more time with this because the first 4 defenses are generally asked more in your examination. So it's necessary that you understand these. ठीक है? So what are the 4 elements? इसको बिल्कुल याद कर लो, so that whenever you read in your examination paper, you don't take a lot of time in thinking. It automatically, the answer automatically comes to you. What is the 4th element? It's that harm must be proportional. Proportional harm होना चाहिए, right? ठीक है, any doubts still here? Now I'll ask you a question. Acha, okay, the first let's understand with examples. So these are the examples that can generally come in your question paper. So whenever you read those examples, it can automatically click that okay, these were the defenses. A person undergoing a surgery is said to have consented to the risks inherently involved. ठीक है, inherently. What is the meaning of inherently involved? Can somebody tell me? क्या मतलब होता है inherently involved? Say for example, you go to an eye doctor, right? Eye के operation के लिए गए हैं, and meanwhile in the operation he gives you an anesthesia. He gives you a general anesthesia, and once you are in the operation table, you are unconscious, you don't know anything, and along with the eye operation he has done something else also. ठीक है, he has probably taken off your kidney or tried to do something else, जो भी है, instead of that eye surgery he has done something more. So the risk is, inherent risk is only with respect to the eye operation. ठीक है, उसके अलावा अगर कोई रिस्क होती है, ठीक है, अ रिस्क विच गोज बियॉन्ड द नीड इज नॉट इंक्लूडेड, ठीक है. Kumud says no ma'am. No ma'am is for, see whenever you write yes no, please थोड़ा सा एक या तो reply के tone में रखो so that I understand what is the meaning of your yes or no. So inherently involved. So I'll ask you a question. Say a person A, she goes for delivery at this particular hospital, ठीक है, hospital B, and here she has the cesarean delivery. Cesarean delivery, I'm sure all of you know, it's not a natural form of delivery, it's a surgical operation is done to take out the baby. And the doctor forgets a scissor inside the stomach of the woman. So will you say it's an inherent risk, or can she claim damages? Okay Kumud, no doubts, great. Yes, tell me. She can claim damages, right, because that is not something inherent. That is not a risk which is inherent in the operation. If a risk was maybe a loss of blood and they could not arrange it in such small time, then obviously those things will depend on the circumstances and whatever is going on. Let me not take you to facts of another case. Next, a player in a game of cricket or football is deemed to be agreeing to any hurt which may be likely in the normal course of the game. ठीक है, likely in the normal course of the game. So say for example, even in WWF, I have seen a few matches of WWF also, WWF or E, whatever that's called. So usme sometimes the players get so aggressive that they start beating the umpire itself. So the point is, the umpire is voluntarily standing there. He is okay with the risk of being hurt slightly, but he has not consented that the players will start beating him, okay, when they get aggressive. So that is how you have to differentiate, okay. What is the third point? A person going on a highway is presumed to consent to the risk of pure accidents, ठीक है. हाईवे पे जाते हैं तो people must be aware कि accident हो सकता है. There is a probability that some person may drive. I mean, pure accidents, obviously you have to separate them from something that has been done by rash or negligent act, ठीक है. A spectator at a cricket match or a motor race cannot recover if he is hit by a ball or injured by a car coming on the track, ठीक है. कहाँ से जा रहा है? So these are the examples. Now let's move on. This is my question for you. This we know. What is this? Try to understand what is this. Try to find out this meaning. Please don't Google, because it will be unfair for others who are actually not Googling these questions which I am asking. Please don't Google. This you already know. What is the meaning of this? I want you to tell me, and then what is the difference? बताओ जल्दी जल्दी. Scientific injury is no injury. So I'll give you one a hint. Scienti means knowledge here. Scienti means knowledge here. Great Kumud, you are at least trying. I'm sure you will benefit a lot. ठीक है? What is meant by compulsory, Devashish? How did you come up with compulsory here? Something bound to happen. No, okay, fine. No, you're going, you're deviating from the thing that which I'm trying to explain. Don't deviate. Just come back. I'll tell you. So, voluntary non-fit injuria, we know to a willing person, no injury is done. No injury is done. However, when I discussed that knowledge, having the knowledge, being aware of it, he must agree to suffer the harm, right? So, this is the corollary, and it means that mere knowledge is not sufficient to avoid. ठीक है? तो basically this is the maxim, this is not a defense. ठीक है? That is the reason that, नहीं Kumud, what is knowingly? Knowingly taking a risk is one thing, and knowingly agreeing to suffer the harm. So basically here you know that there is a risk, but you don't agree to take that risk. ठीक है? समझ आ रहा है किसी को? I'll give you an example after this. But till now, is it understood? कि what does it mean? That you know that there is a risk. ठीक है? But you do not agree to suffer the harm because of that risk. ठीक है? For example, I am standing on a stage here. It's 2 feet tall, and the space is less for me to walk. So I know that there is a risk of me falling down, but I have not agreed to take that risk. ठीक है? If I agree to take that risk, then I cannot claim damages. But if I don't agree to take the risk, then I can claim the damages. So from here I will take you to one case law. Mere knowledge does not mean consenting to the risk is the meaning of scienti non-fit injuria, and that's why we say that general defense is voluntary non-fit injuria. It's not scienti non-fit injuria. Mere knowledge does not mean consenting to the risk. Now this is a very important case, Smith versus Baker. इसके facts बार बार आते हैं examinations में. ठीक है? The factual situation is based on Smith versus Baker. इसमें क्या हुआ था? There was a crane. इसमें बड़े बड़े पत्थर carry होते थे. So this would run from this place to this place. ठीक है? यहाँ से इसका movement था. Now there were some certain workers working here, and they complained that this crane carries such huge stones to and fro all day. When we are working at this position, if any time the stone falls off, we will be in a great risk. ठीक है? So they were complaining basically. And actually one day it happened, unfortunate day it happened that one of the rocks hit the plaintiff and he suffered injury. So these people could not take, ठीक है, could not take the defense of voluntary non-fit injuria. ठीक है? Is it clear? ठीक है, so everybody understood? सबको आया समझ में? Each one of you, if there's any problem, any doubt, please ask me now, because you cannot afford to answer these questions incorrectly. जो करंट वाले आएंगे, जो दूसरे लॉज से आएंगे, there is a probability that you may not be aware of certain current events that time. So इसलिए ये जो static portion है, इसमें full marks चाहिए हमको. We need full marks in the static portion. So you cannot get the questions wrong, and it's very easy. Trust me, it's very easy. Okay, you want a repetition of this particular case? Okay. Okay, क्या नहीं समझ आ रहा है? Can you point out exactly? Scienti non-fit injuria, ठीक है. तो there are two things. What is the meaning of general defense? ये समझ आ गया. Everybody knows, everybody understands the meaning of a general defense. ठीक है. General defense means that if you plead it, you will successfully avoid the action by the plaintiff, right? You don't have to pay any damages. So when I was discussing voluntary non-fit injuria, I said what are the essentials? First of all, the person must be aware of the risk. Secondly, he must have the knowledge plus agreed to suffer the risk. ठीक है, ये हो गया knowledge, and he agreed to suffer the risk. तीसरा क्या था? It was voluntarily done, taken. और चौथा क्या था? Harm caused must not be greater than that agreed. यहाँ तक clear है? Everybody follows? It's clear? Right, right. Now, when we talk about scienti non-fit injuria, they say that this is a defense, this is not a defense. What is not a defense? Key. So, voluntary non-fit injuria, I have mentioned all these four. Now, the scienti non-fit injuria, it means mere knowledge does not mean consenting to the risk. ठीक है? Now, suppose I go to a doctor. I know that I can suffer certain amount of risk, right? But if I sign, I have been given a proforma of consent. If I sign it, only then I am consenting to it, right? To consenting to the inherent risks involved in the operation. Whereas if I choose not to sign this, ठीक है, then I am not consenting. ये clear है? Is this clear? Now let's come to knowledge. अभी जैसे मैंने बताया कि if I have the knowledge that there is a risk, ठीक है, mere knowledge of the risk is not sufficient to take the defense. I must voluntarily agree to take the risk. There is a difference between knowledge and agreement. That is why when we were discussing the essentials, I said that I'll ask you this question, कि first of all he should be aware, and secondly he must agree to suffer the harm, right? So these are two different things. Now do you get the difference between knowledge and agreement to suffer the risk? Is it clear everybody? सबको clear है? Yes, jaldi se. If anybody is still stuck, not being able to understand the difference between awareness of the risk and the agreement to suffer the harm. I'll just repeat this case once again. ठीक है? This is a very good example of the difference between voluntary and scienti. This crane, ठीक है, used to move to and fro from this place to this place. some workers were working here, they used to, their workstations were situated here, ठीक है, their workstations were situated here, right where this process is continued, ठीक है, carrying of stones through the crane, stones मतलब ऐसे छोटे नहीं, बड़े बड़े पत्थर, ठीक है, large stones are being carried from this place to this place through the crane, and there are rocks, ठीक है, rocks and stones. On one fateful day, one of the rocks fell and it hit one of these persons, ठीक है. Now the workers have said, this will be given to you in your fact situation, that the workers have said that, you know, it happens that this crane is carrying the stones from above our heads and it may cause an injury. So we are working, that's not a problem, but please take care because we do not want to suffer the harm which will be caused. Now is it clear? So mere knowledge is not a defense. ठीक है, so the employer will not be able to avoid his liability by simply saying that, you know, it has always been the case that the stones are being taken from the crane, so it's not my responsibility. No, it's not the case. It is one thing to know that stones are going, and it is another thing to agree that okay, if one day stone falls, I'll die, it's okay, no problem. ठीक है? Now is it clear? Now is it clear? If anybody has a specific doubt, see, I don't know where you're missing this point, so if anybody has a specific doubt, please tell me. Clear, okay, fine. So now I think everybody is clear with this. If anybody has any doubt, you can still tell me what your specific doubt is. Where is the problem? All you have to check in defense is that knowledge होना चाहिए, दूसरा क्या होना चाहिए, agreement होना चाहिए कि I'll suffer the risk, there's no problem. If you go to a cricket match, you also have the knowledge and you also agree to suffer the risk, right? We are on the same page here, right? When you go to a stadium, you know also and you agree also, that's why you have bought a ticket and you're sitting there. ठीक है? Third is voluntarily and fourth is proportionality. Next. Okay, so the case studies which I am using here are some of those which have been repeatedly asked in the exams by changing the names and the, you know, stadium ka naam and the name of the plaintiff and other things. So in Hall versus Brooklands, this is a case. The plaintiff was a spectator at a motor car race being held at Brooklands. As a result of the collision between two cars, one was thrown among the spectators, thereby injuring the plaintiff. ठीक है? So whether the plaintiff could claim damages for the injury caused? So the answer is no. Why? Because that danger was inherent. ठीक है? Car races में there are collisions. It's a very normal thing to have two cars colliding and one of the cars can be thrown at the spectators. ठीक है? And the spectator could foresee. Now say for example, this is the ground. Okay, my drawing is very bad. This is the ground and these are the stands. ठीक है? Somebody who's taken this particular stand, he might not agree to take the risk of cars colliding and being thrown at him. Right, but the persons who are sitting right in front, they can be said to have suffered the harm voluntarily. ठीक है? ठीक है, clear? So any question which comes based on these facts, and unless the facts are twisted. For example, I just twisted these facts saying that he took the tickets for the highest stand in a car race, okay, not in a cricket match. So situation and factual situation can be twisted for you to apply your mind. Just keep the principle in mind. अब हम आ जाते हैं नेक्स्ट पे, राइट. लक्ष्मी राजन वर्सेस मलार हॉस्पिटल लिमिटेड. So here the complainant, she developed a painful lump in her breast. The lump had no effect on her uterus, but during the surgery her uterus was removed without any justification. So now they have clearly said a few things. पहली चीज क्या है, that she had developed a lump in a breast, ठीक है. Secondly, they have clearly stated that it had no effect on uterus. And lastly, they have said that uterus was removed without justification. So since these three things they have given you in a factual situation, तो इसका आंसर it becomes very simple. What is the answer? That if uterus was removed without any justification when the actual problem was there in the breast, then the doctor exceeded what he was allowed to do, right? So when he removed the uterus, did she agree to suffer the harm? She neither knew that there can be a problem in the uterus. She neither knew before the time of the operation that the uterus would be removed, and neither did she agree to suffer the harm. ठीक है? The patient's consent for the operation, it was held that it did not imply her consent to the removal of the uterus. Therefore, the hospital was held liable. ठीक है? Clear? Shall we move on? Right. Chalo. This is a question. Tell me. A police constable sustained injuries while trying to rescue women and children from a I think there's something missing here. It has to be a cart or something. ठीक है? 2 horses would have been there and there has to be a cart left unattended in the street by the defendant. So basically, defendant has left 2 of his horses in a cart, and a police constable, in order to save in order to rescue women and children, ठीक है, tries to stop these horses. I'll just write H because I can't draw. 2 horses, tries to stop, and the police constable suffers injuries. अब क्या होगा? What would be the answer? बेटा, what would be the answer? जल्दी बताओ. He cannot claim compensation, Debashish is saying. Anybody else? Jashanpreet, why are you saying? Jashanpreet is saying he can claim compensation. Why is that? Ma'am, he was doing his duty. अच्छा ठीक है, अगर मान लो पुलिस नहीं है, मैं हूँ. If I see 2 horses here and I want to save these women and children, whoever they are, I want to save them from the horses, I jump in. तो फिर क्या होगा? Question is not clear. Okay. Fine. So there is this horse cart, ठीक है? It is left unattended in the road. मुझसे ड्राइंग करवा रहे हैं यहाँ पे. I'm very bad at drawing, okay? So please don't. This is the road. This is a horse cart. ठीक है? Here are the two horses. अबे horse कैसे बनता है? I'm just writing H for horse, okay? And the horses, they are, I think, they are not standing still. ठीक है? There is a probability that they would move and they would harm some women and children sitting here. ठीक है? What does this constable do? I'll give you two situations. Situation 1, this constable intervenes because the horses are now trying to move ahead and they may cause injury to these women and children. So police constable, in the first situation the police constable interrupts, and in the second situation I myself, ठीक है, I interrupt and I try to stop them. Both of us are trying to stop two huge horses and therefore we sustain injuries. दोनों situations में क्या होगा? What would be the answer? Abhishek, is the question now clear at least? Is the question clear to all of you now? Yes, okay, great. Now you tell me the answer. First, your first answer should be just write yes, मतलब claim compensation, no मतलब cannot claim compensation. Situation 1 के लिए और 2 के लिए write 2 and y or n, whatever your answer is. You are saying 1 में cannot claim compensation. 2 में also cannot claim compensation. Okay. So no. Okay. So now I'll tell you that all of your answers are wrong, and that's why I am happy because I'll be explaining a concept that you don't know. ठीक है? Jeevita says 1 पे no, he cannot claim compensation, and why Jeevita? Why will I get a compensation? What is so special about me? I'm happy that I'm so special, but still I would want to know the reason why I am so special that I'll get the compensation and bichara police constable will not. Okay, fine. So both of them will get compensation, right? क्यों मिलेगा? Because there's a word rescue here. ठीक है? And rescue cases are an exception to the defense of voluntary non-fit injuria. ठीक है? सबको समझ आ रही है ये बात जो भी मैंने कहा? Is everybody getting what I tried to explain right now? That you are trying to rescue somebody, and in order to rescue somebody you have voluntarily agreed to suffer the harm. Nevertheless, defendant is negligent, right? Defendant is negligent that he leaves the cart unattended on the road. ठीक है? समझ आ रहा है किसी को? समझ आ रहा है सबको? Tell me. Whenever there is a rescue case, जब भी हम rescue कर रहे हैं, in those situations we can claim compensation and the defendant cannot claim voluntary non-fit injuria. ठीक है, दिस हैपन्स इन रेस्क्यू केसेस, राइट। किसी को कोई डाउट है इस बात में? नहीं। एंड आई एम स्टिल वेटिंग फॉर द आंसर। कौन, किसने बोला था कि मैम विल गेट कॉम्पनसेशन एंड पुलिस वाला विल नॉट गेट? जीविता, right, Jeevita? So I don't know what the reason was, but in any case, even the police, if he's doing out of duty or out of humanity, basically rescue cases में duty नहीं, humanity देखी जाती है. You're looking at the person who's trying to save someone from getting injured, and that is why you are voluntarily agreeing to suffer the harm. Yeah, it's a duty of police, that's correct. It is the duty of the police, but the problem is, it is not the duty of the police to cover up for some other person's negligence, right? ठीक है, that's a sovereign duty, that is agreed. वो duty कर लेगा, no problem, but should we allow the defendant to be negligent and then use the defense of voluntary non-fit injuria कि भाई वो खुद ही आए थे, हम क्या कर? Otherwise, if this person had not intervened, these people would have been injured because of the negligence of the defendant, right? So can the defendant, should, as lawyers or as judges, just think, should the defendant be allowed to take this defense? Should he be allowed to avoid his liability when he was negligent? ठीक है, तो basically when we are talking about tort law, ठीक है, police functions are mentioned in CRPC. They have certain things, certain offences created with respect to police officers in IPC. But when you are talking about torts, it is mainly not to punish the wrongdoer, it's mainly to compensate the person who has suffered the harm. तो यहाँ पे because the defendant is negligent, he must pay the compensation, right? ये समझ आ गया सबको? This is the famous case of Haynes versus Harwood. ठीक है, इस केस में एग्जैक्टली ऐसा हुआ था. देयर वाज अ पुलिस कांस्टेबल एंड ही सस्टेन्ड द इंजरीज व्हाइल ही वाज ट्राइंग टू रेस्क्यू विमेन एंड चिल्ड्रन फ्रॉम अ 2-horse cart, आई थिंक होगा, विच वॉज लेफ्ट अनअटेंडेड. ठीक है, लेफ्ट अनअटेंडेड इज ऑल्सो इम्पॉर्टेंट हियर बिकॉज इट शोज दैट द डिफेंडेंट वॉज नेग्लिजेंट, राइट? आगे बढ़े. So we are done with the defense of, we are done with the first defense of voluntary non-fit injuria. ठीक है, now we are moving on to, now we are moving on to the next defense. ठीक है, वही बता रहे थे. ठीक है, plaintiff the wrongdoer. ठीक है, तो इट्स अ वेरी कॉमन सेइंग इन लॉ दैट वन हु डज नॉट हैव क्लीन हैंड्स कैन नॉट अप्रोच द कोर्ट. ठीक है, इट्स अ सेइंग इन क्रिमिनल लॉ ऑल्सो. ठीक है, जनरली अ पर्सन हु हैज डन समथिंग रॉन्ग और इमोरल, नो एक्शन अराइजेज. इट इज बेस्ड ऑन दिस पर्टिकुलर मैक्सिम. Extirpe causa non oritur actio. It means from an immoral or illegal cause no action arises. ठीक है, तो if the plaintiff himself is responsible for the injuries suffered by him, then he cannot claim damages from the defendant. ठीक है, समझ आ रहा है? Is this clear? This is the legal maxim. You also must remember all the legal maxims that I am discussing in the class. Okay, these are the important ones. The one which you will get in your e-books or LMS, you will have a lot of them. You might not have time to mug them up, but at least these which I am talking, which I am explaining in the class, these are quite important for your preparation. तो इनको ध्यान से पढ़ना. At least remember these, right? So the essential is, first of all, the harm caused should be his own act, and secondly, the plaintiff's acts must be determining cause of the harm. Now tell me why this particular essential is there. What is the meaning of this? थोड़ा आप जल्दी जल्दी चलना पड़ेगा, because I think again I'll be short of time today then. Yes, tell me. What is the reason for the second essential? Is anybody answering? No, first essential is the harm to the plaintiff must be the result of his own act. So this I have already said that the plaintiff is the wrongdoer in this particular defense. See, plaintiff and defendant. Who is the plaintiff? Who goes to the court and says that Judge Sahab, I have been harmed because of the defendant. ठीक है? But actually he is the one who harmed himself. He does something because of which he has been harmed, and he is blaming it on the defendant. So that is the first essential. I am talking about the second essential. Say for instance, there is a road. Plaintiff is going on his cycle. ठीक है, plaintiff is going on his cycle, but instead of this side, he is going at the right side of the road. ठीक है, from here a car is approaching. उल्टा बना दिया मैंने. A car is approaching. He is going towards this direction. From here a car is approaching. ठीक है, ये कार है कि नहीं, कुछ तो भी है. Okay, a truck is approaching, but the driver is a little bit, is driving rashly. ठीक है, but he is also going towards that side ना. He is taking the wrong side of the road. He is supposed to ride his cycle at this side of the road, at the left side. But he is at the right side, and because of the collision he suffers some harm, and he goes to the court and he says कि जी truck driver was rash. Truck driver was. Are you understanding? Because I'm not getting any chats or comments from you all. ठीक है? Okay, great. Yeah, please keep talking to me. Okay, I like when people talk to me. Then the first thing is clear, it is his own act. What is the second thing? The plaintiff's act must be the determining cause of the harm. Now the example that I gave you, इसमें what are the causes for the injury? One is plaintiff's own default, plaintiff's own fault, and second is the negligence of the driver. ठीक है, negligence मतलब हो सकता है मे बी इज नॉट keeping, he has not kept his headlights on, ठीक है, something of that sort. Then what happens is when there are two causes, then for this particular plaintiff, the wrongdoer, for this particular defense, for taking this particular defense, the harm must have been caused by this act. ठीक है, the plaintiff's act should be the determining cause of the harm. ठीक है, and that is to be decided by you on the basis of the facts given to you. ठीक है, if you feel that the plaintiff's act, and it will be very clear in the question, don't worry, it will be very clear in the question, you will be able to figure out whether the defendant's act was equally contributing to the harm or was it only the plaintiff himself because of whose act he suffered injuries. Right? समझ आ रहा है? Sir, I am not audible. Yeah, Jashanpreet, I think you are facing some problems in today's class. You are unable to connect. Right? I hope your internet is working fine. Okay, everybody else can hear me. Am I audible? Great. So now why I explained this concept is because there is something known as contributory negligence. जब आगे हम पढ़ेंगे ना तो there is a concept known as contributory negligence. In these cases where there are two causes and both the causes contribute towards the harm sustained, then it comes within the purview of this particular concept which is known as contributory negligence. So in contributory negligence, there is some default on the part of the plaintiff, there is some default on the part of the defendant. So the court says that okay defendant, you pay damages for your part, ठीक है, proportional to the damage, that pay damages which are proportional to the act which has been caused by you. ठीक है, तो he divides कि अच्छा 50-50 है, ठीक है, and if the actual compensation was 10,000 rupees, तो he will say कि अच्छा ठीक है, if you are 50% responsible for the act, then you pay only 5,000. ठीक है, so that is a okay. Jashanpreet, I would suggest that please disconnect and rejoin. Try to rejoin once again. Sir will admit you once again in the same with the same link. Don't worry. Just refresh your connection, close all the other tabs and then try again. Probably you will get a better connection. ठीक है? Right, so these are the two things. So when you take the defense of plaintiff, the wrongdoer, this particular defense, it means that you will get the complete defense. It's a complete defense, unlike contributory negligence. So इसमें ये होता है कि since the plaintiff is himself responsible for the act, defendant is not liable. Right? That's the crux of this defense. थर्ड पे चलते हैं अब. Inevitable accident. Now that day we discussed vis major, again we will be discussing inevitable accident and vis major. एक minute, let me just check if I haven't missed any slide. Okay, if there is any issue then you can refer to the e-book, right? You can also refer to the e-book. Okay, so let me just use one example because I have not discussed any example other than isme. Let me discuss one example. Yeah. So Rajesh, a truck driver, is employed to transport a consignment of bricks from Rajasthan to Agra. While crossing a bridge, the truck falls down due to its heavy weight and Rajesh suffers the injuries. ठीक है? Now there is a bridge. वो होते हैं ना bridge कुछ बीच में आते हैं and there is a clear warning. Caution दिया होता है कि vehicles only LMV is allowed, only light motor vehicles are allowed. ठीक है? And in spite of looking at the warning, what is he doing? He is taking his truck with a huge load of cargo or whatever that is. Because of this weight, this bridge collapses. You know, generally the bridge should not have collapsed, but since there is a clear warning, when there is a warning ki, you know, your overweight vehicles are not allowed, and still a person is taking a heavy weight truck on this bridge, then he is the, first of all, it is his own act, right? And secondly, it is the determining cause of the harm. Because of being overweight, because of his truck being overweight, which is clearly not allowed to pass the bridge. Yeah, are you getting it? Are you getting my point? Ma'am, if the plaintiff got hurt due to his own negligence, how will he claim half compensation due to his own actions? Okay, Debashish, you know, sometimes there are certain acts which contribute towards the harm. ठीक है? Some portion of it is because of your act and some is because of other person's act. ठीक है? I just gave you this example. This example we'll further study in contributory negligence chapter also. That you know, you are not allowed to ride your bicycle on the right side of the road. ठीक है? Usually we cannot drive our vehicles on the right side of the road. Is that correct or not? ठीक है? That's correct. But in some situations, what you do is, sometimes you take the wrong side. It's a very short distance and you have to take that side because of some reason. At the same time, if a truck driver or if a car for that matter has not switched on the headlights or does not have the license or he is not driving properly, and because of these two causes, see, if there was a headlight and the cycle wala person or motorcycle wala person could have seen that, okay, there is a car, let me wait on the side. If he has taken that much caution, but because of the negligence of the car driver, they have a fateful collision and because of which he suffers the harm, it is a matter of contributory negligence, because you cannot fully forget that even the defendant is liable for that particular act, right? Sometimes it may happen that you are walking in the middle of the road or maybe you are not crossing through the zebra crossing. ठीक है? तो there are certain situations where the defendant's negligence is also taken into account, right? We will discuss this in detail when we deal with the chapter on contributory negligence, don't worry. ठीक है? So in this particular case, it will be his liability, the truck driver's liability. However, now let me read further. If the bridge collapses due to lack of repairs and not due to the weight of the truck, then this defense is not available. So, for example, there's a case MCD versus Subhagwanti. Chalo, we'll read this later. In this case also, there was Chandni Chowk mein, there was an incident. Chandni Chowk mein clock tower collapsed, right? So it is the duty of the municipal corporation to get repairs done every 20 years or 10 years or 50 years, depending on whatever the structure is. So if this bridge needs to be repaired, ठीक है, by PWD or MCD or whatever authority is there for the repairs, if it has to be repaired every 5 years or every 10 years and they have not done their duty, ठीक है, they have not fulfilled their obligation, and this bridge was supposed to be repaired in 2015 until 2021, it's just in that particular state. Now when a truck driver crosses this and the bridge collapses, whose fault is it? Whose fault is it? What is the determining cause? Determining cause क्या होगा? It is not because of the overweight then. Then the cause is because it was not repaired. ठीक है? So that is how the factual position changes, and based on that factual situation your answer will change. ठीक है? So when there is a clear warning, when it's not allowed, तो फिर उसका fault है. But if the bridge is in a very poor condition and say for example warning नहीं है, but they have just mentioned something like limit, weight limit, so then it's not because of this his particular act. But in these cases what the court does is कि देखो, we understand that the bridge had to be repaired, but you should also understand that you should not have taken the risk of crossing that bridge. So in such situations, in such factual situations, what the court does is वो बोलता है कि ठीक है, fine, the bridge collapsed, it was because of the failure of the PWD to carry out the repair work, so they have to pay the damages for the collapse, but some part of compensation will have to be foregone because it was your fault also. You should not have taken the risk of, you should not have taken your truck on that particular bridge. ठीक है? And it all depends on the factual situation which has been given to you. ठीक है? Clear है? तो contributory negligence we'll deal later. अभी फिलहाल we are done with plaintiff the wrongdoer. Let's move on to the next defense, which is inevitable accident. Does anybody have any doubt? No doubts. So let me try and complete this in the next 15 minutes. Inevitable accident and vis major. यहीं पे लिख देती हूँ थोड़ा सा. Vis major we have discussed that day. It's an act of God, right? Act beyond the control of human agency. ठीक है? Because of the working of natural forces. What is inevitable accident? Inevitable accident, there is no working of natural forces, but it is something that happened so suddenly that it could not be avoided. ठीक है? It could not be avoided. So inevitable accident refers to unexpected injury. You are not expecting it, right? Accident is also a defense under IPC. वो भी हम पढ़ेंगे. Expected, which could not have been foreseen and avoided in spite of reasonable care on the part of the defendant. So in law, reasonable is very important. What is reasonable care? That if on a highway you are driving at the speed of 70, 80, it's reasonable care. Whereas if you are driving it on a in a town road, inside the city, if you are driving at 80, then that's not a reasonable speed limit. So the speed limit which has been set by the government also, it is based on reason only. ठीक है कि हाईवे पे यू कैन अलाउ बिकॉज देयर इज अ लॉट ऑफ स्पेस, द रोड्स आर गुड, बट इनसाइड द सिटी वेयर पीपल आर वॉकिंग, देयर आर मार्केट्स, देयर आर स्कूल्स, देयर आर अदर थिंग्स, देयर यू कैन नॉट अलाउ दो स्पीड लिमिट. ठीक है, which was not foreseeable despite all care and caution I think taken on his side, is inevitable accident. ठीक है, so you call it reasonable care. ठीक है, when you are, say for example there's a question on a highway पे I have already given an illustration that highway पे pure accidents के लिए you agree to suffer the risk. तो what is reasonable care? You can't always have due care and attention in highways. ठीक है, my battery is running low now. And what about vis major? Vis major is an act of God. ठीक है, जल्दी जल्दी आ जाते हैं एसेंशियल्स पे. इफ इट्स क्लियर, इफ इट्स अंडरस्टैंडेबल, देन वील मूव ऑन क्विकली बिकॉज आई थिंक आई हैव लेस टाइम. सो फर्स्ट ऑफ ऑल, इट्स एन अनएक्सपेक्टेड इंजरी एंड इट शुड नॉट बी फोर्सेबल. If you can foresee that this thing is going to happen, then it's not an accident, right? Secondly, defendant did not intend to injure the plaintiff. तो यहाँ पे first of all is unexpected या सीधे सीधे unforeseeable. Unforeseeable. What is the second essential? Did no intention. No intention to hurt. And what is the third essential? In spite of taking reasonable care. So they have taken reasonable care. Reasonable care के बाद भी could not avoid injury. ठीक है, right? So these are the essentials for inevitable accident. Something which is unforeseeable. Secondly, you don't have intention, and thirdly, you have in spite of the reasonable care. Once you could see that something is going to happen and you took all reasonable care, in spite of that the accident could not have been avoided. ठीक है? Let's move on. So here is an example. Rakesh and Shahrukh are in a forest hunting pheasant. What's a pheasant? It's a kind of a bird. ठीक है, peasant से confuse मत होना. Rakesh, while carefully aiming, shot at a pheasant. The bullet strikes a tree and rebounds and hurts Shahrukh in the arm. ठीक है, तो what is the answer? Rakesh is not liable. अब पहले बताओ, forcible था? Forcible था? नहीं था. They are saying carefully aiming. ठीक है, तो negligence भी नहीं था. Reasonable care was there. Could not be avoided. ठीक है, तो basically this happened in spite of being careful. ठीक है, और rebound कर गई, strikes a tree and rebounds. This is not foreseeable and it hurt Shahrukh, and he did not have an, sorry, second point was he did not have an intention. साथ में ही गए थे, ठीक है, for hunting, so there was no intention. Right? Let us move ahead. अगर किसी को कोई doubt है तो बताओ, otherwise I'll just move ahead. So basically the injury to Shahrukh was purely due to an accident, and such a turn of events could not have been foreseen by Rakesh, who had taken due care. ठीक है? These are the facts based on a case called Stanley versus Powell. Don't worry if you don't remember the case laws. I don't think they ask you specific case laws. अगर कुछ होगा तो आते आते आ जाएगा. If you can remember, no doubts. Right, great. So now we move on to act of God. Act of God, vis major or force majeure. We have already discussed. So now, act of God, we are coming up to the fifth defense, right? The injury must arise due to the working of natural forces. So that is the difference between accident and act of God. ठीक है? The occurrence must be extraordinary. ठीक है? If you say that because of an earthquake of 3 magnitude, a building fell down, then is it an act of God? नहीं, because we have categorized earthquakes on the basis of their severity, right? कुछ earthquakes जो बड़े होते हैं उनके लिए a person can be held liable, उसके लिए we can say it's working of natural forces, but if it's a mild earthquake then the problem lies with the persons who are responsible for repair work and other things. So it should have been extraordinary and should not be one which could be anticipated and reasonably guarded against. ठीक है? तो when I spoke about a 3.0 magnitude of earthquake, I meant that now we have the technology to reasonably guard ourselves with what? Disaster resilient structures. You know, these terms which I use, they may be helpful in your GK and other things also. So please take note of these words. Disaster resilient infrastructure है हमारे पास. ठीक है? तो you know, you must have read these things in your disaster management class because it's a compulsory subject, I believe. Class 10th, 11th, 12th में होता है, right? Somebody respond if it's there. Disaster management as a subject. Nobody? No, you did not have. So, but you got my point, right? An extraordinary event must be there. जैसे flood हो गया. Flood is also a natural disaster, but a very mild flood will not amount to an act of God. तो act of God के defense के लिए something extraordinary which cannot be anticipated or reasonably guarded. Now since we have the technology for having disaster resilient infrastructure जल्दी से मैं बता देती हूँ क्या होता है कि घर कैसे बनता है. पहले ऐसे बनता था, because of a landslide or earthquake this will fall off. Now we have different kind of technologies in which we can design or we can structure houses or buildings in such a manner that an earthquake of even a higher magnitude like 5 or 5.5 cannot damage them, right? Any doubt here? Extraordinary होना चाहिए and could be one which could be not one which could be anticipated and reasonably guarded. ठीक है? Let's move on then if you have no doubts. The wall of a building in Old Delhi collapsed due to an unprecedented rainfall in July, which was the maximum in the past 25 years. The children of a labourer who were nearby, who was sleeping near the wall, got severely injured. The owner of the building is not liable to compensate the children for their injuries. The injuries have resulted due to the exceptional amount of rainfall which could not be anticipated and guarded against. ठीक है, no doubts. Ma'am, like cyclones come and we know about it through technology, it's forcible. That's correct. So if a cyclone is coming, say ओडिशा में जो आया था, अम्फन हो गया, कोई और हो गया, तो जो cyclones आ रहे हैं, if a cyclone is approaching and if we are prepared for it, ठीक है, if we have reasonably now for a cyclone also there are some things for which you can prepare and there may be some other things for which you cannot prepare. Even though you know that it's approaching, there are some things that you cannot manage. So it depends on the, again I'm repeating the same thing, it depends on the factual situation that has been given to you, whether, and you will definitely be able to apply the principle to that situation and get the correct answer. ठीक है? Okay. आगे बढ़ते हैं. Now, similarly, in the above example, suppose heavy rainfall occurs in Assam resulting in a collapse of the wall. The children can seek damages from the owner of the building. Assam is prone to heavy rains and a reasonable man ought to keep this in mind while constructing buildings. See, so these kind of situations will be asked to you that this particular area is prone to heavy rainfalls. So the owner must be prepared. ठीक है, अब राजस्थान में अगर कोई ऐसा हो जाए, if suppose in Rajasthan there's a rainfall and there's an exceptionally high amount of rainfall, then it's an act of God, right? But in Cherrapunji, it's not an act of God. He ought to take adequate safety measures to ensure that any accident does not occur. Thus, if such an accident happens in Assam, it cannot be called unforeseeable. ठीक है? So क्या क्या है? Unforeseable है और exceptional है, cannot be anticipated है, can't be anticipated, can't be guarded against. All these things, right? So let's move ahead then, move on. So it's a case of Nichols versus Marshland. This is also asked. The defendant created some artificial lakes. ठीक है? फिर क्या हुआ? On his land, damming some natural streams. Once due to an extraordinary heavy rainfall, stated to be the heaviest in human memory. The embankments of the lakes gave away, the rush of water washed away 4 bridges belonging to the plaintiff. Now tell me whether the defendant can be held liable for the damage caused. जल्दी से बताओ. Not liable, not liable, okay, not liable. If I say, if in the principle I give you the concept of strict liability, फिर will your answer change? Or it will remain the same? Will your answer change or it will remain the same? If I tell you that a person is strictly liable for his use of land, something like this. I am only writing strictly liable, I am not writing its components, remember. Everybody is saying yes. So what are the essentials of strict liability? If anybody remembers, किसी को याद है? First is non-natural use of land. It is satisfied. I'll not write the second one right now. Third is it escapes the premises. This is correct. Fourth is there is a damage caused. This is also correct. But what is the second one? What is the second essential in strict liability? It is a hazardous substance. Hazardous or dangerous. So depending on the factual situation, if the artificial lakes are of such a nature that they are of hazard, they have hazardous substance or they are dangerous, only then the strict liability principle will apply. Right? If that is not true, then you have to go by this particular case, that since this particular rainfall was heaviest in the human memory, that's why it's an act of God. An act of God is a defense in strict liability. समझ रहे हैं बात को? Act of God is a defense under strict liability. Where is it not a defense? In absolute liability. ठीक है? क्या डिस्कस किया था हमने उस दिन? What did we discuss the other day when we were reading the CLAT paper? That strict liability and absolute liability are the same thing. Only difference is strict liability has certain exceptions, absolute liability has no exceptions, right? Don't forget this part. Strict liability clearly gives you, in strict liability the principle clearly states that act of God is an exception to the rule of strict liability. So, if in 25 years or in human memory this was the heaviest rainfall and this is an act of God, then the strict liability principle clearly does not apply. ठीक है? Clear? Can we move on? Okay, last few things. Next is private defense. Private defense is also a defense under criminal law, IPC sections 96 to 106. We'll talk about private defense and we'll discuss this in detail when we are doing the law of crimes. Every man is entitled to use of a reasonable force to protect one's own person or property. The use of force is justified only on some essential conditions. पहली चीज क्या हो गई? Reasonable होना चाहिए force, ठीक है? और दूसरी चीज क्या हो गई? To protect. It means that a person who claims the right of private defense cannot claim that he is doing because the other person did it. It cannot be an act of revenge. सिर्फ बचना है उसके एक्ट से. All we have to do is protect ourselves. Once we are protected, then we cannot run after the person that I'll take revenge. Let us see the conditions. First is imminent and immediate threat to the person or property. So, for example, a thief comes and he steals your purse and then he runs away and you are unable to catch up with him. You cannot follow him to his place. Now tell me, can you try to find thief some other day and then start beating him? Can you do that? सर कुछ आंसर आ रहा है क्या?
नो मैम, आंसर इज,
एक सेकेंड,
आंसर इज फ्रॉम कुमुद चंद्र, नो मैम.
राइट, सो दैट इज करेक्ट. सर मुझे ऐड कर दीजिएगा, मैं फ़ोन से लॉगिन हो रही हूँ, उसमें से वो हट गया. ठीक है, तो द थ्रेट शुड बी इमिनेंट एंड इमीडिएट. सो वेन एवर इन अ केस स्टडी you are given this example that there was a threat to your person or property and then a person started running away. Say for example, you shot in the air, you shot around in the air and the person started running away. Once the person starts running away, you no longer have the right of private defense because the danger has been averted. Right? We'll discuss this very in detail when we are discussing the right of private defense under the Indian Penal Code. Right now, the first essential is it should be immediate. What is the second part? The force used by the defendant must be necessary to ward off the attack. ठीक है? Necessary to ward off the attack. Only that amount of force can be used which is necessary to ward off the attack. You cannot, ऐसे नहीं कि somebody has come to somebody is threatening you and you fire a shot at his head. No, that's not allowed. If you can fire a shot on his leg, even then it will ward off the danger. ठीक है? So I could not see your answers till now because I was unable to see the chat. I can see you all now. I can see the chat now. And what is the third? So second is it should be necessary and proportionate. ठीक है, सामने वाला धक्का दे रहा है उसको जान से नहीं मार देंगे. ठीक है, if somebody is trying to push you, trying to assault you, you cannot kill him and tell them that, you know, I was just protecting myself. I took the defense of protecting myself. The force used must be for the purpose of defense and not for the purpose of taking revenge. So similarly, when you talk about necessity and proportionality, these are the two doctrines. Again, I am saying that we will be discussing them in crimes, but it will become easier for you to follow then if you understand the basics right now. तीसरा क्या है? Not for the purposes of taking revenge. ठीक है? Everybody is getting it. If someone slaps us, we cannot shoot him with a gun because it's not reasonable force. That is correct. Right, that is correct. तो आगे बढ़े. If there is no doubt till now, I think I am running a little short of time, so just read this. Alok is attacked by a sworn enemy, Aman, who rains fist blows on Alok. To protect himself, Alok blocks his move and overpowers Aman. In the process, Aman suffers some injury. ठीक है, if Aman sues Alok to claim compensation, he will not succeed. Alok was acting in self-defense and used reasonable force to defend himself. ठीक है? So only blocks and he only blocks and overpowers him. Next में चले जाते हैं तो फिर क्या होता है? Where he cannot claim the defense. Suppose Aman attacks Alok, Alok overpowers Aman and continues to beat him mercilessly. Aman suffers extensive injuries. ठीक है? इस situation में क्या होगा? He is said to have exceeded his right of private defense. ठीक है? It's great that you don't have doubts. So I am guessing that you just got your 6 plus. You got 12 marks right now. ठीक है? If you have no doubts, then I am assuming कि अब तक जो पढ़ा है उसके हिसाब से you are getting 12 marks correct. Right, even when Aman was rendered helpless after Alok overpowered him, he was continuously beaten, therefore he cannot claim the right of private defense. Let us move ahead. Bird versus Holbrook. This is also a very important case. It's been asked again and again in the examination, where the defendant has put up the spring guns. Spring guns पता है ना क्या होते हैं कि there's a fence. Fence पे नहीं कुछ देखते होंगे, कुछ पत्थर लगा दिए किसी ने. Sometimes they are stone, pieces of broken glass. So spring guns is also a kind of thing यहाँ पे जो लगी रहती है to repel the person who is trying to invade without fixing any notice about the same. So what he has done is he has put spring guns, but he has not put any notice about the same, and a trespasser was seriously injured by its automatic discharge. ठीक है, anybody trying to cross over will sustain injuries because of its automatic discharge. इसमें क्या होगा, whether the defendant could take the defense of private defense, इसमें आंसर होगा plaintiff was allowed to recover. ठीक है, he cannot claim the private defense because the harm sustained was greater than what was required. ठीक है, एक trespasser के. Now say for example in the instance they say that there is a warning raised, clear warning that there is a ferocious dog, or there are spring guns, or there are wired fences, live wired. नहीं, live wired is still ज़्यादा हो जाता है. It's an excessive use of force. But anyway, without warning, if it's being done, it's always excessive. Okay, and you cannot take the. He cannot, right? Now, mistake. So mistake is also something which we will deal not only in this section. That's why I am skipping these portions thoda jaldi, because we will dealing with them in contracts also and in IPC also. So don't worry. Generally, mistake in an action for tort is not a defense. ठीक है, generally is not a defense. Mistake of fact and mistake of law. Now two types के हैं, एक है fact का और एक है law का. तो mistake of law तो कभी is never a defense. Why? Why is it not a defense? Last 5 minutes, okay, last 5-10 minutes. Tell me. Why is mistake of law not a defense? Yes, Jashanpreet, that's correct. When a defendant acts under a mistaken belief. Yes, everywhere. Otherwise, everyone would use it as a defense, and it's based on the maxim, ignorance of law is no excuse. ठीक है, it's based on the maxim, ignorantia non juris excusat, right? Ignorance of law is no excuse. What about mistake of fact? In certain situations it's allowed. ठीक है, but generally in torts it's not allowed. Let us see the example. An auctioneer was asked to auction certain goods by his customer. He honestly believed that the goods belonged to the customer. So for example, I have stolen the goods of Kumud. ठीक है, I have stolen the goods of Kumud and I go to Jashanpreet. Jashanpreet is the auctioneer. Now I tell Jashanpreet that, you know, these are my goods and please sell them, auction them and give me the proceeds. So Jashanpreet says कि हाँ ma'am is saying कि it's her property, I'll just sell this and I'll give whatever I get to ma'am. Now what happens is, when Kumud sees that okay, this is my property which is being sold, so if Kumud says that auctioneer, you better pay me compensation because you have sold my goods, ठीक है, you have sold my goods and you have given the sale proceeds to some other person, then in that case, in an action by the true owner, here the true owner is Kumud, ठीक है, the auctioneer was held liable for the tort of conversion, ठीक है. So mistake of fact is generally not an excuse in an action of tort, ठीक है. He may later, now if you say कि नहीं ये तो गलत हो रहा है auctioneer के साथ, then he may later sue the person, he may later sue me कि you know you came up with stolen goods and I truly believing you, I sold them. So that is a separate thing. But here in an action by a true owner, the auctioneer would be held liable. Only in the cases of malicious prosecution, if there is an honest belief that you know this person has done this particular act, he has committed an offense, if I honestly and truly believe that, in these cases, in the cases of malicious prosecution, the mistake of fact is a defense. ठीक है, are you getting it? So कोई और अगर normal सा mistake, don't worry, don't say that oh law is not good, he'll get the he'll be indemnified by the person who has stolen the goods, ठीक है, he'll be indemnified by under some other law, but under this particular law he'll be liable for tort of conversion, ठीक है. Right, let's move ahead. Necessity as a defense. So necessity is again something which has to be done, ठीक है. Doctrine of necessity states that something needs to be done, some harm needs to be caused to avoid a greater harm, ठीक है. बोलते हैं ना नेसेसरी इविल बोलते हैं ना किसी चीज को, तो वो यही होता है कि समथिंग व्हेन देयर इज अ चॉइस बिटवीन टू इविल्स देन वन इज ग्रेटर देन द अदर, तो हम स्मॉलर हार्म करते हैं. वी चूज द स्मॉलर हार्म एंड वी ट्राई टू अवॉइड द ग्रेटर इविल. द डिफेंडेंट मस्ट एक्ट टू अवॉइड द ग्रेटर इविल. In so doing, he is bound to commit some small injury. So basically, when I am choosing between the two, I know that both of them will cause harm, but I am choosing one particular harm because according to me, that is a smaller evil and this thing which I am trying to avoid is a greater evil. ठीक है, there must be no viable alternative to avoid both evils. ठीक है, तो देयर इज नो अल्टरनेटिव. यू कैन नॉट से कि नहीं नहीं गलत करना ही क्यों है, मत करो. नो, सो इट्स नॉट पॉसिबल. ठीक है, इट्स अ सिचुएशन ऑफ, it may be a situation of accident where your car brakes have failed and you can either turn the car left or you can turn the car right or you can go straight. यहाँ पे बच्चे खेल रहे हैं, यहाँ पे एक पर्सन है और यहाँ पे 3-4 लेडीज हैं, तो the best option is to go to the right side even though you know that this person may suffer a harm. ठीक है, it depends. There's a series. What is like trespass? I didn't get it. What are you writing? Like trespass? There must be no viable. There must be a situation which requires urgent attention of the defendant. So यहाँ पे जब when he is driving a car which has its brakes failed, then it requires the urgent attention कि you have to choose immediately. So at that moment he has to choose the smaller evil which he thinks, ठीक है, according to him, which will be later judged by the judges. Now what is the difference? In a minute I'll tell you. Necessity versus private defense. In private defense, harm is caused to the wrongdoer, whereas in necessity the harm is caused to an innocent person. ठीक है, उनकी कोई गलती नहीं है, but that has become necessary to cause harm. Necessity versus inevitable accident में क्या है? Inevitable accident cannot be avoided in spite of efforts. However, in case of necessity, harm is caused intentionally, right? So there is no intention in accident, in inevitable accident, but here, although your intention is pure, but the situation is such that you know that I will be causing the harm. ठीक है, तो the harm becomes intentional and not accidental. किसी को कोई doubt तो नहीं है? Now, in the middle of the night, Mahesh wakes up to find that his kitchen is on fire. Panicked, he rushes to his neighbor Karan's house to fetch a large house pipe, which he knows that Karan has. He uses that pipe to douse the flames. ठीक है, तो हाँ, trespass के case, this is a case of trespass versus protecting own property. So there are two houses. This is my house, this is somebody else's house. There is a pipe here in this particular house. My house is on fire. Now what do? I rush to his house without taking anybody's permission. I use the water which he has and I start using the water to put off the fire, right? So in this situation, I have chosen a smaller evil, smaller injury, that is trespassing the house of another person to avoid a greater harm. Greater harm, मेरा घर जल जाता, ठीक है, my house would have been burnt. So in the above example, suppose Mahesh's house is on fire and there are firemen already working to control the fire. Then you are not justified in trespassing others' land and getting pipe of water, because the fire brigade is already working. ठीक है? The last defense is statutory authority. Statutory authority, what does it mean? An authority which has been created by a statute. What is a statute? It is an act passed by the legislature, ठीक है, competently. तो great Jashanpreet, you already knew the example, correct. Now, so statutory authority is an authority which has been created by an act of parliament or the legislature. So if a legislature has authorized the doing of any act or directs an act to be done, then the damage resulting from it is not actionable even though it would otherwise be a tort. मतलब वो सारे torts ये सारे torts हैं, but some part of it has been authorized. ठीक है, some acts are authorized. Then this part will not be an, you can take the defense of this part and then the damages will not have to be paid, right? Clear hai? Is it clear? One more thing is important to be noted, that it's not the thing which has been authorized, not only the thing which has been authorized by the statute, but also something which is incidental. ठीक है, तो जैसे आर्मी के लिए कोई लैंड बनाया, if you have segregated a portion of land to be used by the army or the air force for flying of fighter jets, and because of that there's a lot of noise pollution, then you can't do anything about it because the lands have been created under a statute. Of course, this will be, if this is a factual situation being given, then they also have to mention that this is done by a statute, right? What are the essential elements? They must be authorized by law, and the authorized act must be done strictly in accordance with law and in the prescribed manner. So one more thing which is necessary for you to understand, it should not only be authorized by the law, it must be done in accordance with law. जैसा बोला है वैसा करना है, ठीक है, the way it has been mentioned, in the prescribed manner, in a lawful manner, ठीक है. So you cannot exceed the statutory authority defense. In that defense, the competent authority cannot exceed what has been authorized by law. It must not be done negligently or in a reckless disregard. ठीक है, is it clear? Sorry, I took a lot of time, 5 minute बोल के. An important security related practice at airports is frisking of passengers, which has been duly authorized by law. The passengers cannot complain of the inconvenience and claim damages for such an act. ठीक है. But while frisking, if the security personnel manhandles the person, ठीक है, uses undue force, ठीक है, तो उस केस में क्या होगा? It goes against the authorization of the law. It's not in the prescribed manner then. ठीक है, समझ गए सब? Right? So in such a situation, the passenger can claim damages. So finally, I am done with today's class. If you have any doubts, I am giving you 1 or 2 minutes, then I'll wrap up. Tell me, Jeevita, what doubt do you have? Acha, about LMS, yeah, tell me. So yeah, one more thing, guys, whoever has received the credentials, please log in through that credentials, and you will be getting your topic tests and sectional tests very soon. We are almost done with the finalization of schedule. You will be getting all of them. दो चीज़ें हैं. One, please join the Telegram channel. ठीक है, all the faculties and the mentors and everybody is there on the Telegram channel. So whenever you are unable to log in, अच्छा OTP नहीं आ रहा है. Okay, so these things, what you can do is please join this particular Telegram channel. It is called the MLC Scholars 2021. ठीक है, check out your email. email में लिखा होगा ये, ठीक है. The first email that you have received, उसमें कुछ आया होगा join chat करके Telegram. Please join that group. I think many of you have joined that group also, and whatever doubts you are having with regard to OTP and everything, so LMS वाला portion, it will be looked by Brijesh sir, ठीक है, your English faculty. जो भी problem आ रही है इन सब चीज़ों में, you can speak to him. I would suggest कि non-academic doubts के लिए just join this channel, and you can just post whatever your doubts are. Don't hesitate, be frank. And all these kind of doubts you can straight away write in the Telegram channel. Okay? Okay. Thank you guys. Thank you so much.